Native title is the designation given to the common law doctrine of Aboriginal title in Australia, which is the recognition by Australian law that Indigenous Australians have rights and interests to their land that derive from their traditional laws and customs. The concept recognizes that in certain cases there was and is a continued beneficial legal interest in land held by Indigenous peoples which survived the acquisition of radical title to the land by the Crown at the time of sovereignty. Native title can coexist with non-Aboriginal proprietary rights, and in some cases different Aboriginal groups can exercise their native title over the same land. The foundational case for native title in Australia was Mabo v Queensland. 1 year after the recognition of the legal concept of native title in Mabo, the Keating government formalised the recognition by legislation with the enactment by the Australian Parliament of the Native Title Act 1993. The Act attempted to clarify the legal position of landholders and the processes to be followed for native title to be claimed, protected and recognised through the courts. The Federal Court of Australia arranges mediation in relation to claims made by Aboriginal and Torres Strait Islander peoples, and hears applications for, and makes, native title determinations. Appeals against these determinations can be made to a full sitting of the Federal Court and then to the High Court of Australia. The National Native Title Tribunal, established under the Native Title Act 1993, is a body that applies the registration test to all new native title claimant applications and undertakes future act mediation and arbitral functions. The Attorney General's Department advises the Australian Government on legal and legal policy regarding on native title, and assists the Attorney General to administer the Native Title Act 1993. According to the Attorney General's Department gives recognition that Aboriginal and Torres Strait Islander people have rights to land, water and sea, including exclusive possession in some cases, but does not provide ownership. It allows for negotiations over land, but does not provide for a veto over development, and nor does it grant land, as the Aboriginal Land Rights Act does. National Native Title Tribunal definition. The communal, group or individual rights and interests of Aboriginal people and Torres Strait Islander people in relation to land and waters, possessed under traditional law and custom, by which those people have a connection with an area which is recognised under Australian law. Commonwealth Government's indigenous.gov.au website. Native title is the recognition in Australian law, under common law and the Native Title Act 1993, of Indigenous Australians' rights and interests in land and waters according to their own traditional laws and customs. Native title has also been described as a bundle of rights in land, which may include such rights as camping, performing ceremony, etc. If native title is granted, specific rights are decided on a case-by-case basis, and may only sometimes includes freehold title. Australia did not experience litigation involving Aboriginal native title until the 1970s, though several earlier cases tangentially involved issues of native title. In 1835, John Batman purported to sign Batman's Treaty with Aboriginal elders in the Port Phillip district. Governor Burke declared Batman's treaty was void and of no effect as against the rights of the Crown, and declared any person on vacant land of the Crown, without authorization from the Crown, to be trespassing. The proclamation was approved by the Colonial Office. The official objection to the treaty was that Batman had attempted to negotiate directly with the Aboriginal people, whom the British did not recognize as having any claim to any lands in Australia. In 1971, in Miliapum v Nabalco Pty Limited in the Supreme Court of the Northern Territory, Justice Richard Blackburn explicitly rejected the concept of native title, ruling against the claimants on a number of issues of law and fact, but rejecting the doctrine of Aboriginal title in favour of terra nullius, which held that land belonged to no one at the time of British settlement. In the wake of Miliapum and the election of the Whitlam government in 1972, the Aboriginal Land Rights Commission to collective Aboriginal ownership, the Fraser government continued to implement many of the previous government's initiatives. under the description, self-management, rather than self-determination. In 1979, Paul Coe, a Wiradjuri man from Cowra, New South Wales, commenced, as plaintiff, an action in the High Court of Australia arguing that at the time white people came to Australia, Aborigines were there and therefore the court had to recognise their rights. Coe's claim was never heard due to serious deficiencies with his statement of claim. Justice Gibbs said, at paragraph 21, the question what rights the Aborigine